Good evening. On behalf of the New York Technology Council, we're pleased to have you all here. We really have a great turnout this evening, which is, we're very pleased. This is a great event and one that we enjoy putting on. Before we get into the presentation this evening, I'm going to tell you a little bit about the New York Technology Council. My name is Paul Ellis. I am a founding board member of NYTECH, and I also run the legal track of events, which is what you're at this evening. The New York Technology Council is a nonprofit industry association dedicated to promoting and supporting the technology industry in New York. We do that through educational activities such as this, community building, workforce development, and advocacy efforts, both here in New York, in Albany, and in Washington, D.C. We have over 40 events per year, which includes educational events like this, the CEO roundtables, and other types of events, networking events. We have annual memberships and sponsorships available. So those very few of you who are not currently members or sponsors of NYTECH, this is your opportunity. We hope that many of you will join. As we are a nonprofit organization, we really count on your support in order to help us to engage in the sorts of activities that NYTECH is involved in. We have a growing list of organizations that are our annual sponsors. I'm not going to read them all, but you can for yourself. We are very pleased to have so many organizations that are involved in supporting NYTECH, and again, we urge you to get your organization to come on board. In particular, this evening, we want to extend our thanks to Anchin, our host for this event, in this really cool space that we're in. The event this evening, Legal Essentials for Startups, Structuring the Entity and Founder Agreements. So again, my name is Paul Ellis. I am the principal of the Paul Ellis Law Group. That's a 6-lawyer boutique firm here in Midtown Manhattan. We are all corporate and IP lawyers. We do a lot of work with small and mid-sized tech companies in areas including formation, financing, intellectual property protection, licensing, joint ventures, employee issues, and exits, mergers and acquisitions, or buying and selling companies. We're all big firm lawyers. We started at big firms and have big firm training, but we all now work in a small firm where we're able to offer the specialized sort of expertise that you get at a big firm, but at the more reasonable cost structure and with the more personalized attention of a smaller firm. Because of the amount of work that we do with technology companies, we have a lot of connections into the space, so we can often assist our clients with things such as referrals to investors or other people they need, like consultants, accountants, and the like. So that's me. The rest of the panel I'll introduce briefly, and then they can say a few words about themselves. Leading our panel this evening, we're very pleased to have Helen Reeves, who is an associate at Frankfurt Kurnit. And Helen, you'll say a few words about yourself. We also have Jerry Spiegel, a partner at Frankfurt Kurnit, and we have Kevin Saer, a partner at Wright Tremaine. I think we have a great panel. I think we have a great event this evening. With that, Helen, I'll turn it over to you, and then everyone else can follow you.
So I want to thank Paul for that introduction. As he said, my name is Helen Reeves. I'm an associate at Frankfurt Kurnit in Midtown Manhattan. My primary work at the firm is with startups. I'm in the corporate practice there, helping startups with everything from the formation to, the financing of the entity. We'll get more into that throughout the entire presentation, the formation piece. But very excited to be here and very excited to lead this discussion. So, Jerry, do you want to just briefly introduce yourself?
I'm Jerry Spiegel. If you did meet me outside, I'd love to meet all of you. We run the corporate and technology practice at the firm, and we work with a lot of startups. So Helen is expert in the area, and I'm looking forward to her presentation tonight.
My name's Kevin Saer. I'm a partner at the law firm of Davis, Wright, Tremaine. We have an office here in the city, and throughout the country we have other offices. I, like Paul and Jerry, Helen, I do a lot of early stage company work. We also do a lot of general corporate work, mergers and acquisitions work, and we're pretty much a full service firm in terms of doing corporate employment, intellectual property, and litigation law. But we tend to focus a lot on early stage companies and particularly technology companies.
So the first thing we're going to talk about are the preliminary considerations in starting up an entity, starting up an actual business and forming the legal entity. The next thing we'll talk about is choosing that entity, what the different options are. Third, where we're going to organize the entity, what jurisdiction. Then governance issues, ownership, other considerations, and then key takeaways. So preliminary considerations. So you're about to start up your business. But before you do, you want to ask yourself some very key questions about the business that you're about to start. Does the idea that the business is hinged on belong to someone else? So if you're an employee and you've created this idea in the context of your employment, are there any agreements that require that that idea, be assigned to your employer? This is a very basic issue that comes up quite a bit with a lot of our startup clients, where they come in and they have this excellent idea and they've spent all this time at work thinking about it, and as it turns out, they basically created it for their employer. So you want to think about that. Same issues with non-competes and also with non-solicitation agreements. If you are working with an employer that's had you sign up those kinds of documents, you want to think about that first before you go off and try and launch a business that might not really be your own. So assuming that those are not any issues, assuming the answer to those questions is no, then you're ready to start. So there are many considerations when you're thinking about when to organize the business. Maybe you're spending a lot of your time, your free time, on the idea. Maybe you finally come up with a way to commercialize the idea, to generate revenue. Maybe you have a group of founders and you want to finalize or kind of formalize what the ownership arrangement is, what the employment arrangement is, if any. You might also want to contract with third parties or get financing. It could be any number of the things on this list that might make you say, I think I'm at a point now where I want to come up with a real formal business and form an entity.
The one thing I just wanted to add, because in my experience, a lot of people will come to us and say, I work at this company, I've been asked to sign this non-compete. I signed it a few years ago. I've been told by everybody that it's not enforceable. And my brother-in-law says they'll never enforce this against me. So I'm free to go and do what I want. But you have to be very careful about that, because generally those are enforceable. And especially people who are working with relatively sophisticated companies, there's pretty much an accepted practice within the industry of what these things look like, and they generally are enforceable. We're not in the state of California where they're not enforceable. It's New York State. They're disfavored, but they are enforceable. And even if they're overbroad and potentially subject to some kind of cutback, you really don't want to be in a situation where your first experience with your startup is defending a litigation from your previous employer. That's a pretty standard recipe for failure when you're first out of the gate is you're fighting with your employer as to whether you own the idea or you have the ability to actually do what you want to do. So I would just say, a lot of people sign these documents when they're employed. They don't give them a lot of thought. They go in a drawer, nobody looks at them, and everyone's told that they're not enforceable. But take that with a grain of salt, because there are really teeth to those kind of things.
Helen, I think I'd jump in here on about when to organize the business. I think a crucial issue that you need to think about in the beginning is when you have, it's the third bullet point, need to formalize founder and employee relationships. At the point when, if you're not a solo, if you have other partners who are involved with you, or if you are planning to bring on employees or consultants and you want to give them equity, that is a moment when you have to formalize things. Because if you get things set in the beginning, whether you have a company formed, you have a shareholders agreement, equity issued, you know what the terms of the equity are, those are things that are relatively easy to take care of in the very beginning. But what will often happen, and I've seen happen many times, is that people delay on that because, well, they're so busy, pushing the idea out, they want to be first to market, whatever it is. They don't get the shareholders agreement done, or they have some vague deal with awarding equity or whatever it is. And as time moves on, it becomes more difficult to figure out what that deal actually was. And maybe people didn't have an agreement on what the deal was. And something that could have been resolved very quickly and easily in the beginning becomes a point of contention. And I've seen probably a couple of small companies that they came to me after the fact and said, how do we sort this out? And frankly, it couldn't really be sorted out. And a company that could have survived and could have thrived, there was so much acrimony between the founders that it ended up tanking, and they went their other direction. So do not delay on your formation, on your shareholders agreement, on awarding equity, having the terms of that set, because that can cause problems down the line.
Yeah, I would add one other comment to that, which is, while I agree with the concept that is an appropriate time to form an entity, if your client is just not at the point where they're ready to do that, you can suggest that they have an agreement amongst the founders as to what the entity will look like when it's formed. So there is something a little short of actually forming it that you could do.
I have a question. Even before that point, you're having discussions with potential partners. How enforceable is a non-disclosure? And how important is a non-disclosure? You can have discussions with potential partners and get to a point where you've given them a lot of information, and all of a sudden they say, you know, I'm not really interested.
Well, non-disclosure agreements are enforceable. The cost of enforcing them makes them effectively non-enforceable at that level.
Right.
But the threat of enforcing it can sometimes have an impact.
The threat has a cost.
We always, well, writing a letter is a lot cheaper than bringing a lawsuit. Reminding that person that they've agreed to this and could be subject to a lawsuit can sometimes bring that around. It's at the very least you should have that agreement in existence.
Yeah, and another thing there that comes up often, even in the M&A context too. Like, how much can we disclose? We're a small company. We're dealing with this bigger company. If they breach, what can we really do? You might want to think about a concept like staged disclosure. You don't give away the secret sauce in the first meeting. You see how invested they are. Are they engaging lawyers? Do they have accountants? Are they doing due diligence and spending time and money and effort in looking at my company? Have they expressed a real commitment to this deal, or are they just kicking the tires and taking a look? So that's more of a practical way in which you can manage that situation a little bit, is to stage the disclosure you give based on the level of their commitment.
That would work for a VC as well.
Yeah.
Well, except VCs don't like to sign non-disclosure
Right.
agreements.
And they generally don't go out there stealing people's ideas for the most part.
But the concept is the same, to have staged disclosure, whether it's for the formation stage or with investors or when you're selling the company. Don't give people more information than they need in order to get to the next stage. As I always tell my clients, the best way to keep something as a secret is don't tell anybody.
Right.
So, and generally people over disclose. They disclose more than they need to. All that you need to do is disclose enough to get people to the next stage, and then you decide what's appropriate.
I was going to pick up on your point, because I've gone to a bunch of angel investors who say, all of them say, they will never sign an NDA. And unless you provide enough inspiration in your initial presentation to them, you're toast.
Well, staged disclosure.
Yeah.
But you can understand it from their perspective too, because they're seeing so many companies. They don't want you crawling out of the woodwork saying, "Oh, this company you developed 6 months, that was really my idea."
That's right.
So they just won't do it.
Yeah,
They really won't.
Yeah, and I mean, we all represent angel investors, and my angel investor clients, I won't let them sign NDAs,
Right.
for good reason. But the point is, you're going to be out of business as an investor pretty fast if the word gets out that you're leaking secrets or you're taking something to another company. So generally, I think you need to be more careful with angels than with VCs. And you have to, a more professional angel is more reliable than a less professional angel. But generally speaking, investors tend to be careful of that.
It's the investment bankers you have to watch out for.
Oh, Jerry, you're always knocking.
No, there's a
on
famous
the
case
bankers.
involving Cosmo and Urban Fetch.
Choosing the business entity. make sure we.
They could have either one of those businesses.
That was the investment.
So,
The idea.
business structure considerations. Which business structure should I choose? So, some of the considerations a lot of times come down to tax, the specific circumstances of the founder. Are you foreign? Are you U.S. founder? Your business plan, your anticipated operating strategy, how will the business be funded, and what is your anticipated exit? So we're going to walk through five different business startup entity choices. The first being a sole proprietorship, the next being a partnership, LLCs, and then corporations. There are two varieties. So on the sole partnership, if you're an individual who owns 100% of a business and you haven't done anything, you've started running the business, you're generating some revenue from it, you are by default a sole proprietor. So you have a sole proprietorship. The drawback of this is that you're completely exposed. There's no limitation on liability for a sole proprietorship. So that's typically why people try to, when they start the business, form some type of legal entity. But if you don't, you are in this category. Typically, as a sole proprietor, you will file a doing business as DBA application to try and give your business a separate name. So you might be, Helen Reeves doing the actual business, but I might have a DBA on file of, Reeves Systems, for my actual business.
So just the key thing there really, I'm sorry not to interrupt, but the key thing there is really when you're operating in that format, you're not a separate legal entity. You are the business. So there's no distinction between you personally and the business. So anything that could happen that could result in a potential liability becomes your own personal liability. So I think the sole proprietorship's fine when you're just out there trying to develop an idea. But I think when you get beyond that stage, you really should be thinking about setting up some kind of an entity that's going to afford you some liability protection. You're going to be able to do things like issue equity and put some more formal arrangements in place. But the default, if you're just out there operating a business, you would be considered a sole proprietor.
So then if there's more than one of you, operating this business and you haven't really formalized it, then you're in this partnership category. Partnerships are pass-through entities for tax purposes. So partners, all the income from the partnership gets passed through to the partners, typically based on their ownership, on their personal tax returns, on their 1040s. So partnerships are really kind of rarely used as startups, typically because investment funds and certain investor vehicles can invest in partnerships. But if it's just the two of you and you again haven't actually formalized a legal entity, this would be the bucket that you're in. There are two types of partnerships: general partnerships and limited partnerships. In a general partnership, all partners are personally liable for any debts or claims of the partnership, and both partners or multiple partners can manage and act for the general partnership. In a limited partnership, there's at least one general partner who is actually on the hook for liabilities related to the partnership and participates in the management of the business. And then there are other limited partners who don't participate in management and have no liability with respect to those debts. And you'll often see in the investment fund scenario, you'll see that they'll be set up as limited partnerships with a GP that manages the fund, and then passive LPs that receive income but don't manage. You guys want to touch on that at all?
Yeah, I'll jump in here for a moment. I think the important thing about the partnership slide is to recognize if there's more than one of you and you have not formed a company but you're working on a business together, this is the default. This is where you end up. And generally speaking, this is a place you don't want to be.
You don't want to be here.
And don't go here. And I think if you look at the general partnership, that sort of tells the what's the worst part of the story. First of all, let's say it's you and a couple of three guys. You started a business together. You haven't formed a company. All three of you are personally liable for the liabilities of the partnership, incurred by any one of you. So any one of you can incur liabilities that all three of you are liable for. In addition, focus on the fact that any one of you can bind the partnership. So any one of you can do a deal on, that binds the business that you are working on together without the consent of the others, and you could find yourself in a very bad situation if you let yourself slip into the default of a partnership. So that's why, especially when you have multiple people who've started a business together, it is important to, at the earliest possible point, make sure you've either formed an entity or at least you'll have some type of written agreement among them.
Quick question, follow-up question. At what point is a partnership formed? If you say it's the default and you have initial discussions, at what point does it actually become a partnership versus
It's pretty amorphous, but
Yeah.
basically when you have 2 or more people acting together to carry out a business, you're a partnership. Under state law, you'd be considered a partnership. So there's no real bright line there, but if you and me are out there doing stuff in connection with a business, we're technically a partnership. And again, like Paul was saying, it's not really where you want to be because it's got all these potentials for personal liability and me binding you to agreements that you really don't want to be liable for. So I don't think there's really any startups that are knowingly out there running as general partnerships. Probably a lot that are and don't know it, but I don't think anyone intentionally wants to be there.
So when you're in that gray area of where you have an agreement of what the business is going to look like before you form an LLC, you're pretty much a partnership.
You are.
Yeah.
Until you
Yeah.
form an entity that takes over the business is by default a partnership of the individuals.
I mean, you can have an agreement that said, I won't do X without Paul and Jerry's consent. We won't act that way. But as far as third parties are concerned, if you're out there holding yourself out there as a business, you have apparent authority to bind that business. So even though we might have an agreement that says, I won't incur, I won't go borrow $100,000 without them agreeing to it. As far as the bank's concerned, that's going to be a liability of the partnership, and in turn, a liability of all of us personally.
Which is why a founder's agreement is better than nothing, but not a whole lot better than nothing when it comes to the outside world. So.
Form an entity, avoid the problem.
Speaking of which, LLCs. So limited liability companies can be formed by 1 or more persons, filing articles of organization in the case of New York or certificates of formation in Delaware with the appropriate state. The owners of the LLC are called members and enter into an operating agreement governing all the things we've been talking about. So ownership, management, allocations of profit and loss, distributions of cash. This is where you kind of set out the meat and potatoes of your business if you're forming an LLC. So what are some of the benefits of forming an LLC? Well, you've got, first and foremost, that limitation of liability. So members have no personal liability beyond the value of whatever they've contributed for their equity in the business. You've got tax flexibility. LLCs can elect to be taxed as corporations or as pass-through entities for federal and state income tax purposes. So you have this ability to choose as an LLC member how the LLC will be taxed. You can also play around with the way profits are allocated to members, so it doesn't have to be in accordance with what you own. So you can have 3 members of an LLC who are each owning the business a third, but maybe one of the members has another business that they want to allocate losses to. So they may say, you know what, I'll be allocated all of the losses from this business for a certain period of time. We'll paper that up in the operating agreement because that benefits me from a tax perspective, and we'll operate that way. So you don't have to have this match between the ownership and the way that the income and loss are allocated as between the members. And then lastly, there's potentially favorable tax treatment on an asset sale. So the third benefit we want to highlight too is management. It's pretty easy to set up the management of an LLC. The members can manage the LLC, or you can appoint 1 or more members to be managers of the LLC. It really is up to you. And you can set that all out just in your operating agreement, how you want to do it. So you've got some really great benefits here. I want to highlight again the first one, limitation of liability, because that's really what we've been talking about throughout this early part of the presentation. And we'll get into more detail about the others. You guys want to touch on anything specific?
Yeah, I just want to touch 2 points on personal liability. Just be aware that notwithstanding the fact that these entities we're talking about have limited liability, that doesn't mean that there's no potential for liability. There are actually certain things you could be liable for as an operator or owner of a company, including copyright infringement. And I mention that because we're dealing with technology companies, so forming an entity is not going to insulate you from copyright infringement liability if you are infringing somebody else's copyrights. And with respect to the tax treatment, having an LLC will give you a favorable result on an asset sale, but actually you're better off with a corporation if you're going to do a sale of stock or stock for stock transaction. And you need to anticipate that. So the point being, none of these things are bright line absolute rules. There are exceptions to all of them. So pay attention to the basic rules, but be aware that there are, exceptions to them that you need to take into account.
And just to add to that, and this comes up in the LLC context and certainly in the corporate context, respecting the corporate formalities, making sure that you actually are operating the business as its own separate business is key to preserving, this limitation of liability. So setting up a separate bank account for the business. I mean, you'd be surprised. I have a lot of entrepreneurs walking through that use their personal bank account for their business bank account. That's one very clear way to just destroy that, potentially erode that limitation of liability, and that respecting the business as a separate business. Actually keeping corporate documents, we'll get into more of this later, but having consents and approvals of key material decisions of the members, actually using the operating agreement and respecting what you've set up is critical to maintaining some of these benefits.
And one other thing that was touched on, and I don't know if everyone exactly understands what it means, but when we talk about pass-through taxation, that's one of the key attributes of a limited liability. It has this pass-through taxation. So that means for federal income tax purposes, any taxable income passes through to the owner. So if the three of us each own an LLC in equal shares, a third each, and we have $100 worth of taxable income in the company, 1/3 of it will be taxed to me personally, and 1/3 to each one of the other owners. So the tax liability of the entity actually flows through to the people who own it. So there's no tax at the entity level, but the people who own the company have the tax on the income. Now that has some positive attributes in a way, because if you do an asset sale, you don't incur 2 levels of tax, but also you have to be mindful that if the entity is profit making and has taxable income, that's ultimately going to be a liability of the owners of the business.
And that's a liability even if you're not distributed in cash.
Right,
so,
right.
So if no cash is actually distributed to you, but there's income, you still have to pay the tax on that income. So there often will be provisions for tax distributions and operating agreements to allow for the company to at least distribute, to the extent that it can, cash so that each of the members can cover their tax liability.
And that can be a particular concern if you're not controlling, like if you control the LLC, if you own the whole thing or you own a controlling share, you can control when those distributions are made. So if the company has money, you just distribute it out to yourself to pay your taxes. But if you're a minority owner and the majority owners don't, for some reason, want to keep that money in the business and maybe have tax losses that they can otherwise use to shelter that income, you can be in a little bit of a tough position where you have this, like Helen was saying, this phantom income where you're recognizing income, but you don't have the cash to pay the tax on it. So it's just something to be aware of.
Could you touch on the benefits of establishing the LLC in Delaware as opposed to?
We're going to touch on that in a little bit when we get to where to structure, but yes, definitely. So we've talked about the benefits of setting up an LLC. We want to make sure we talked a little bit about the drawbacks. So we talked about corporate formalities. One thing we haven't touched on is incentive compensation. So if you've set up an LLC and you want to hire a developer, or you want to hire a couple of folks to just do some discrete work, maybe you just want to pay them some incentive options. It's more difficult to do with an LLC. It's not impossible to do. There are structures to do it. You can do non-qualified options. You can also do profits interests, but it's not as easy to do as with a full corporate structure. LLCs are usually not appropriate for VC and offshore investors. Oftentimes, these vehicles will have restrictions on the types of entities that they can invest in, so a pass-through vehicle might not work for the investment community that you're looking at. So that's something else to consider. For New York LLCs, there's a publication requirement. So it's an additional filing fee that you've got to pay to publish in New York State. It's a bit archaic. I'm not sure why it's still in place.
I don't think anyone knows what it's still in place.
What do you mean? It was your Jerry Finkelstein. That was a Jerry Finkelstein tax.
But it does.
He owned the Law Journal, so.
It can be, for a startup, it can be, it adds, if you're in New York County, it adds about $2,500 to $3,000 to the cost. So if you're a small business, that's something you really have to think twice about, because it's really just money flushed down the toilet. I mean, it has absolutely no purpose, and it is a significant cost for an early stage company.
go back to what you were just saying. Why is it more difficult for an LLC when you're diminishing in terms of, for example, hiring a external piece of discrete work? Why is it more difficult versus a corporation?
So,
are there specifics?
So with an LLC, you can't issue qualified stock options. You can only issue non-qualified stock options. So qualified stock options, I'm not going to get into, you guys can get into all the details if you'd like, but just simply, qualified stock options give the company a special tax treatment and also give the recipient of the qualified option a special tax treatment. So non-qualified option isn't really as good for someone, in that position, and also for the company. And then also you can use a profits interest, but profits interests are a bit tricky. You've got to do a valuation of the business to set the threshold amount for that profits interest. What a profits interest is, it's essentially an equity grant to your developer that gives them the right and the upside from the date of grant. So if you grant someone a profits interest and the company's valued at $1 million, the value of that profits interest is zero at the time of grant. But as the company appreciates, if there was an exit and the company was sold for $2 million, they would have to wait for that $1 million to get distributed to the other equity holders, but they would share in the upside after that $1 million. So it can be complicated to structure and also complicated for a developer to understand. It's sometimes difficult for our clients to understand. So that's kind of a little bit of the color behind that. Do you guys want to?
Yeah, I might jump in here. I think Helen's absolutely right in terms of the equity comp. Although I would, to some extent, it's a little more difficult. But I think and I'm sure we certainly do equity comp plans for our LLC clients. It's not so much a matter to me of difficult, but as Helen says, the tax treatment is not as favorable for an LLC as for a corporation. But beyond that, I mean, we do LLC equity plans all the time. People just need to be aware that there are some disadvantages. Generally speaking, when I'm advising my clients as to choosing between LLC and a corporation, I tell them I wouldn't let that be a deciding factor in terms of going with a corporation instead of an LLC. To me, there are much more important factors, such as the potential benefit on an asset sale of an LLC. The fact of the equity comp is something to be aware of, but I wouldn't call it a gating factor. The other thing that I'd mention is that certainly it's true New York LLCs have to meet state publication requirements, but actually any LLC operating in New York needs to meet publication requirements. So if you form in Delaware or any other state, as long as you are doing business in New York and need to qualify in New York, you need to meet this publication requirement. And as Kevin says, it ain't chump change.
It's actually slightly more expensive if you're a foreign LLC because they require additional information.
Yeah.
So.
And the last thing I'd say is on the last point, the complex legal documentation and accounting. This is something to take seriously. And again, when I speak to my clients about deciding between a corporation and an LLC, I tell them, with a corporation, the tax treatment is relatively straightforward, and you're not going to have to think too much about it. With an LLC, every time you need to do something significant with that entity, whether it's an equity plan or a new class of equity or bring in another member, or virtually any significant thing, it has tax consequences. And that means that I'm going to be on the phone with my tax colleague figuring out how to handle the tax treatment in connection with that LLC. And you, as a founder, you're going to have to think about, well, do I want to do it this way, or do I want to do it that way? And if I do it this way, it has these implications, and that way has those implications. So that's the one thing that I think is important as a take-home about LLCs. And I tell my clients this: an LLC may be the right choice for you, but remember, the day will come when you'll be like, another tax issue with my LLC, and I'll say, remember, I warned you that this day would come. And it's a nuisance that you have with LLCs. It does add cost. It adds complications. I don't believe it's enough to make it worth choosing a corporation over an LLC because of the other benefits of an LLC, but it's something that founders need to be aware of.
The one thing I would just add, and I'd be interested to hear what you guys think about this topic. I mean, my biggest reason as to why I would encourage an early stage company to do a C Corp is just because of the venture community. I mean, LLCs have been around since 1994. They're used in a ton of different contexts, but for some reason, you get to a stage where you're going to do your Series A and they're like, convert to a C Corp. We don't want to deal with this thing. It's like, and it's not necessarily because they care about the pass-through taxation, because they can figure out ways around that. You know, you can have mandatory tax distributions and other things. It's just that they don't they like what they like. You know what I mean? And they like how they've done it for years and years, and they know what a Series A round looks like in a C Corp, and they don't quite know what that looks like in an LLC, and not all the concepts are easily translatable. So I can't tell you how many times it's a great idea. We start out as an LLC, the companies love it, and then they talk to the first VC, and it's great, become a C Corp.
Let me, if I could tell a little story about this, which was probably the most interesting situation of this type that I had, but I had a client who formed as an LLC here in New York, and they went out to do their first seed round, preferred round, and no, we did, the first round was a convertible note, and they sold about half the round to individual angel investors, and then the client was got an intro to some of the VCs out on the West Coast, and they went out there and they came back, and basically all the big name VCs that you know were all decided that they all wanted to invest, and they didn't want to wait. They wanted to invest in that very first round. So, and they wanted to invest in a C Corp. So we had to, we talk about additional costs, Paul, we had to terminate the offering halfway through. It was a $4 million round, so we had $2 million raised. We closed the round at $2 million. We then immediately prepared new offering documents and converted the LLC to a corporation, and went back out and sold the rest of the round for the $2 million to the VCs. That round, that conversion cost twice what the initial offering round cost in terms of our fees. Because we not only had to do the new offering, we had to close the old offering and then really figure out how to take all the terms from the LLC and convert them into the C Corp. So there is a lot to be said for that position. And while I started my business in this area, really selling LLCs, I don't do that anymore. I mean, I'll set them up as LLCs if the client wants it. But I honestly feel at some level that it may just not be worth all the trouble to have the LLC. I kind of am coming around to the opposite point of view, but.
Yeah, I mean,
I don't know, I agree with that. That's my point. I don't think they're worth it. I think the clients don't understand them, the investors don't really understand them, and the positive tax attributes you get, which is the pass-through taxation and favorable treatment on an asset sale, you can structure a deal as a stock deal or something else. You can get around, if that's, I haven't really seen that as being the deciding factor, if somebody won't buy your company or somebody won't sell your company because you need to do it as an asset sale and they won't do it as a stock deal. So I just, you can work around that in a purchase agreement with appropriate indemnities and holdbacks to protect people. So I don't know, I just find that it's more and more that it starts out as a great idea, but it ultimately becomes like a hindrance.
Headaches are not worth it.
I think it's worth touching on something that Jerry said, is that the aspect of conversion. Because it's relatively easy to convert from an LLC to a corporation, but it's complicated and potentially expensive to do the other way. And I should qualify relatively easily because Jerry told the appropriate war story. If you do the conversion when the capital structure is relatively straightforward, then it is relatively easy. But if you have issued rounds of equity and preferences, and you've got an equity plan out there, and God forbid you've issued profits interests, heaven help you. Because as Jerry says, then the conversion is difficult, it's expensive in terms of legal fees, and it's just a nuisance. So if you start as an LLC and you anticipate you have a VC round, an institutional round coming up, then convert early and convert before you have, complicated your capital structure, because it'll be no end of headaches.
Wouldn't it make sense to take the tax losses as a startup LLC so that you could actually recognize those through your personal taxes and then convert to a C Corp when it comes to the point where you're raising that kind of money?
Well, I mean, we have a difference of opinion here on the panel, because I really like the tax benefits of an LLC for my clients, and Kevin's right that you can structure a deal as an exit as a stock or an asset sale, but generally your pricing is better in an asset sale. You as the seller will get more for your company in an asset sale than in a stock sale. So I agree with everything that Jerry and Kevin have said. What I tell my clients is you need to think this through, and you need to think through what the future may bring. There are meaningful tax benefits to starting as an LLC. If you know that you're going to be bringing in an institutional round early on, skip it. Go right to a corporation. But if you may be operating for a while and you want the benefit of those losses, and you want to be able to distribute them, I mean, investors like to mess around with how the losses are allocated. You get that benefit in an LLC. If you get to an exit without having taken an institutional round, then you may get financial benefits in an exit from an LLC. But there's no question. So you're right. There are potential benefits to starting as an LLC, but as Kevin and Jerry have said, they can become headaches really fast. So you need to think it through and get your timing right.
I'm going to move to corporations, since we've been talking about them so much. So corporation is a separate legal entity with limited liability. We all know owners of a corporation, stockholders, management, directors, and then officers that kind of run the day-to-day. And a corporation is said to be a legal person. So we've kind of touched on some of these things. You file a certificate of incorporation with your state to form the corporation. There's a management, with the board of directors and officers designated. So let's talk about some of the benefits, and let's talk about some of the drawbacks of setting up a corporation. So you have a separate taxable entity, with a corporate entity, limitation of liability for shareholders, obviously with the exception of you have to respect the corporate formalities we've talked about. And Delaware C Corps are known and pretty much appreciated by professional investors. So you have an audience that will be open to investing in your vehicle. Salary and incentive compensation plans are a lot easier to implement. You have the favorable tax treatment with qualified incentive stock options. So that's one reason why, among the many others that we've discussed, people choose a C Corp corporation. Some of the drawbacks. So there's two levels of taxation with a corporation. So there's taxation on the actual income, which the business pays. And then if there are any dividends or distributions that are made out to the owners, they pay tax on that as well. So that's one of the biggest drawbacks of a corporate structure, having those two levels of taxation. Limited flexibility of management in their capital structure. So remember, with LLCs, you can just, in your operating agreement, set out that you're going to have certain members just as members, and certain members will be managing the business. With a corporation, you've got to set up a board, you've got to, really set out all of the process for that in a more structured way. Directors and officers may not be limited in connection with their performance of their duties. So we know that directors and officers have fiduciary duties to the business. So there's obviously issues there if we choose to be a director of the corporation. And then maintenance of the corporation can be expensive and time consuming. So you've got to file a separate tax return for your corporation, which you didn't have to do with the LLC. These are some of the drawbacks potentially, which we can definitely get into in more depth of setting up a corporation. Do you guys want to dig into this?
Well, I'll show my bias again in favor of C Corps. I mean, you hear a lot about the two levels of taxation associated with the C Corp, and that's true. I mean, that is, but you got to understand, most early stage companies lose money. So like this idea that, I need to shelter all the taxable income I'm going to have, it's not that important, guys. It's really not. Right? You're going to lose money in the early stages. And if there are things you can do to minimize, especially if it's a closely held entity, there's certainly things you can do to minimize the level of tax that the corporate entity might pay. For example, you can pay yourself a salary right? So that becomes a corporate expense, and now the corporation that's not taxable income to the corporation because they've got a corresponding expense associated with salary or bonus that you pay out. So in the early stages, you're either going to lose money or you can manipulate it in a way where you're not really going to have any significant income at the corporate level. So this idea of 2 levels of tax, while there's a benefit to it, I just don't want to oversell that idea that you really have to be an LLC, because if we're not an LLC, we're going to be in this like really unfavorable tax environment. By and large, you don't really feel it that much.
Just as a footnote to that too, I mean, if the corporation is actually making money, this concern about distribute any dividends that are paid being taxed. I mean, oftentimes with a startup, whatever little money you're making, you're just going to reinvest into the business. You're not going to necessarily pay out to the founders some huge cash dividend. So, again, to your point, operationally and practically speaking, when you're in that very, very early stage, any free cash you have, you're probably not going to be, sending out or distributing out anyway. So, I also agree that that's kind of a false drawback.
Yeah, I would agree with Kevin on that also. I think the 2 level of taxation argument is not really relevant to most early stage companies. And while there are tax benefits to an LLC that make it worth considering, the pass-through taxation, at least for the early stage, is not one that you should really spend a lot of time worrying about, because rarely do we see our clients.
Should be so lucky.
Yeah, exactly.
Be so lucky.
It's a high-class problem to have.
Right.
So now we move to S-Corps. So S-Corps are corporations, but they elect to be taxed as pass-through entities. So if your mind wasn't already spinning from our discussion of LLCs and corporations, and just add another red herring to the mix. So S-Corps, you can elect to be an S-Corp by first forming the C-Corp and then filing an S election with the IRS within 75 days of formation to be treated as an S-Corp. One of the big things that makes kind of S-Corps tricky is that at any given point you could do something to trip or violate that S election. So, and I'll get into this in the next slide, only certain parties can be holders of equity in an S-Corp. So if you inadvertently transfer equity in an S-Corp to someone who's not eligible, that S-Corp will lose its S election status. You can only have one class of stock in an S-Corp. So if you want to go out to investors and raise a preferred stock round and you've got common stock out there, you will lose your S election. So this is one reason why, and we'll get to this obviously later, S-Corps can be very, very tricky to deal with. So we thought it'd be helpful to lay out kind of a side-by-side comparison of S-Corps and C-Corps. Some of this we've talked about already, so I'll kind of breeze through certain things. For example, we talked about how S-Corps just now are pass-through vehicles. They're like LLCs in that regard, and C-Corps have this double taxation component. S-Corps have, in some ways, have the same aspects of an LLC in the sense that they're pass-throughs, but they're locked in the sense that you can't allocate income to stockholders outside of their ownership. So remember we talked about how if I start, Helen Reeves LLC and I have 3 members and we're a third, we can allocate income and loss as we choose. With an S-Corp, you can't really do that. So in that way, it still kind of falls into this corporate structure. And then there are certain limitations listed here for S-Corps on who can hold equity in the S-Corp. So your stockholders have to be U.S. citizens. So this is another consideration. If one of your founders is not in the United States, setting up an S-Corp just won't work. You can only have one class of stock. So if you're going to be going out for investment and raising a preferred round, S-Corp really doesn't make that much sense. So these are the kind of things that we would, constantly counsel to a startup founder to think about. Next slide.
Well, I think I would just say that we rarely ever use S corporations. I don't know about my colleagues here, but we'll use them for entrepreneurs who have a business that they want to run and they're not looking for investors and they're not looking to build something bigger, but they need a pass-through entity. They don't want to deal with things like the unincorporated business tax. They're making a lot of money, things like that. But generally speaking, when we're talking about startups and building a tech startup, I rarely ever see S-Corps.
Yeah, that actually flows into the next slide of S-Corps versus LLCs.
I mean, I think of it as really like it's for the mom and pop. It's for the bagel store. It's really not an appropriate vehicle for for a startup entity. But if a husband and wife or family-owned business, something that you see them like that, it's really for the mom and pop shop. That's what the S Corp is designed for.
Jerry kind of touched on this already, but S Corps are not subject to the New York unincorporated business tax, whereas LLCs and sole proprietorships and partnerships are. So that might be one reason why you choose to use an S Corp over an LLC. Also, there was I think Kevin made the point about salary. You know, if you've got an S Corp and you can actually have the salary come out first. And also, the employment taxes will be withheld by the S Corp, so the founder in the LLC has to pay those taxes on their own. So we've just laid out here a couple of ways to compare the two and consider the two.
You know, Helen, I'm not sure that it's been made clear, and I think it's worth clarifying, but if you're a member of an LLC and the LLC is paying you regular weekly, monthly payments in the nature of salary, they're not deemed to be salary for tax purposes. They're deemed to be distribution, so they're not a deduction or an expense. And that's sort of one of the big differences between taxation of an LLC or a partnership and a taxation of an S Corp or a corporation.
No, thank you for pointing that out. I don't think that was clear in here. So now you've decided on the entity and you want to figure out where to organize. So you can organize in any one of the 50 states. Wherever you are doing business, you have to be qualified to do business, so that might be a consideration. If you know that you're going to be doing business in New York, then maybe you want to organize in New York. Each state requires that any entity that's organized in another entity and then comes and does business in their state, so a foreign entity or foreign corporation, be qualified. So in the instance of a Delaware corporation that's doing business in New York, you know, I think we talked about this earlier, you've got to qualify to do business in New York, you've got to pay taxes on any income that's generated in New York. So really kind of thinking about where you're going to be doing business is an important component, but ultimately as your business expands, you may need to qualify in additional jurisdictions to stay current with your taxes.
And the idea of qualification, like being let's say, for example, if you're a Delaware corporation, you have to qualify in New York or New Jersey or other states where you do business. It's a very simple process. So it's not really much to it at all, other than filling out a form and filing it with the Secretary of State of that state. So it's, you know, the idea that there's going to be an extra administrative burden associated with, you know, forming an entity in one state and having to qualify in all different states, it's really negligible in terms of the work involved and the cost.
Some other considerations, recognition and acceptance by potential investors. So we've talked about this a little bit, but Delaware has a very well-established body of corporate law. It's very well known and accepted by VCs and professional investors. So if you know you're going to go out for that type of investment, having a Delaware corporation is kind of, it's a gimme. It makes investors feel comfortable. You know, the geographical location of the business, corporate income tax rates may be a factor for you. Any publication requirements if you're an LLC forming in New York. So these are just a few of the relevant considerations when you're thinking about where to form. So we've talked about Delaware, we've talked about New York, we've talked about the home state where the founders are actually located. However, the applicable laws where the business is carried out also apply to the entity. So if you're formed in Delaware but you're doing business in New York, you can be sued in New York even though you're a Delaware entity. And you know, you have to obviously pay your income tax in wherever state you're in. A very interesting deal recently where a client was running a business of schools, and they did have a couple of places where they owned real estate, so they qualified to do business in those places. Then they were running a couple of like small sessions. You know, they would go to another state to test out their business model there, and they would, you know, run a couple of sessions there, and they weren't sure if they really needed to qualify to do business there. And I actually want to pose this to the panel of, at what point are you really doing business enough to need to qualify to do business there? Because this comes up a lot for startups that are just doing a little bit here and a little bit there.
I mean, I always say if you have a physical presence in a state, I tell my clients to qualify. If you don't, I don't really have them qualify. But generally, if you have a physical presence, you have employees or an office located in the state, I'd say you have to be qualified in that state.
Right. There's a list of factors, but those are really the ones that
Yeah,
are most
the fact, like in New York State, the law is, they don't give you a list of factors that tell you when you have to qualify, they tell you when you don't have to qualify, actually. So it's really not, the law isn't that helpful.
What if you have founders in different states?
Well, their residence is not necessarily where they're doing business. So, I mean, we have, being in New York, you know, we deal with people who live in Connecticut, people who live in New York, people who live in New Jersey, maybe even Pennsylvania. It's very common for us in our practice to see that. But the issue is, where is the business being conducted? Where does it own assets? Where does it have offices? And so typically that's a single location. But yes, sometimes you have virtual companies and everyone's working out of their home. And if you're working out of your home, but you're not working to the public in the state, does that mean you have to qualify in the state? So these are the issues, and they're not necessarily simple issues, and sometimes you end up having to do things you'd prefer not to just to make other people happy. So.
I hope that this is a quick one. You mentioned the publication requirement for New York State, and needing to qualify. Are those two different things?
The publication requirement is for LLCs.
Okay.
Okay, and it's a New York only requirement. Nobody else requires it, and it's for any LLC that is formed in New York or does business in New York.
But it comes up in connection with qualification, right? Because you can't, it is when you want to qualify, or I should say, if as a Delaware LLC you want to qualify in New York, you're going to need to publish in order to qualify in New York.
So they get you either way. That's really the bottom line. You know, New York won't let you do business here either as a home LLC or a foreign LLC without paying that publication cost. That's
Right.
Oh, that's right here.
As an internet business,
Oh,
do I have to worry about all the states where I'm doing business?
I don't think this is really a good forum to discuss that, but the issue of where you're deemed to be conducting business for tax purposes is complicated.
yeah, and open. Right? It's not quite
And
settled
is an issue for the tax lawyers and the accountants,
Yeah.
not us.
there's a question over here.
Yeah, just a quick one. Any particular disadvantage forming in New Jersey for LLC or C Corp compared to New York?
Yes.
Yeah,
Yes.
I agree.
New Jersey is a pain in the butt. And I have the wounds to prove it. Okay? I mean, I actually had one deal, I can just say it was one transaction, I guess it was around 1999. I had a client that was receiving a significant six-figure investment into the company from a VC. And as part of it, we had to reincorporate the company from New Jersey into Delaware. And I had no problem with Delaware. They took the papers and they filed them. New Jersey refused to accept the papers for 2 weeks until I got on the phone to the service company and I said, who's the agent that's holding this up? And they gave me their name and phone number, and I called them and I said, if you don't pay, I said, this is idiotic. And if you don't do this, I'm calling your boss. And I literally had the thing approved 30 minutes later. But seriously, that's a funny story. It's a true story. But I can tell you a number of times that I have had difficulty extracting a company out of New Jersey that was formed there. They're just very difficult.
Can I follow up with a question? So if I already have a single member LLC myself in New Jersey, and I've been persuaded here and otherwise that it should be a C Corp, let's say, where would I
Where are you doing business?
Sorry?
Where are you doing business?
Out of New Jersey.
You're in New Jersey? Your employees are in New Jersey?
No employees.
Just you?
Yeah.
Well, look, you
I know
have...
that I'll get investors. I mean, I'm hoping. I'm going to work on it. And then I will convert. Yeah.
You have to be in New Jersey because you're doing business in New Jersey, right? So you have a choice. You can either set up the corporation in New Jersey and pay one tax in New Jersey, or you can form it in Delaware and go through all that hassle now, or you can wait to go through the hassle until you get the investor. And if I were you, the latter would be
Yeah,
my
I would
choice.
Wait, I would wait too. But you have to understand, like, it's, again, when I was talking about with the LLCs versus the C Corps, you know, any VC, any lawyer for a VC, they all understand what Delaware law is. They don't necessarily understand. I don't know too many New Jersey VCs or a lot of, I'm sure there's a ton of Jersey lawyers that do early stage company work, but you're sort of narrowing the field. You know, everybody knows, in the legal community, in the investment community, everybody knows Delaware. So just keep it simple. Just do Delaware. You just start with Delaware, you don't have to ever change it, and that's it.
You gotta be in Delaware.
I'm an advocate
You
for
gotta be-
Delaware. But
It's just really, we can talk about the different alternatives, but if you're an early stage company and you're looking for investors
Yeah.
or an exit or something, you should be in Delaware.
Right.
You know, it's just,
95, I mean, you know, don't reinvent the wheel on this stuff. I mean, I got so many, even New York companies that I'm doing rounds for, they say, well, you got to migrate that thing to Delaware. Just put it into Delaware. We don't want to bother with even learning about what New York corporate law is, even though it's, you know, probably, you know, most
Probably,
corporations are
yeah.
doing business.
which is not to say it's not necessarily a knee-jerk reaction. I mean, there are issues, you know, in New York law that
Yeah,
you
that's
know,
true.
there's a rule under New York law that the 10 largest shareholders are responsible for any unpaid compensation to employees of that company. So if the company goes bust, that VC is on the hook for wages that weren't paid to the employees. VCs don't like that. You know?
Well, you know that in New York, the members of an LLC are personally liable for sales tax. Not
So,
too many
I mean-
people know that.
I mean, there are all sorts of substantive reasons, as well as, you know, it's convenience. It's, you know, it's the fact that, you know, but lawyers understand. You know, all lawyers know Delaware law, regardless of whether you're a New York lawyer or a New Jersey lawyer or a California lawyer or a Pennsylvania lawyer. You know Delaware law. That in itself makes deals easier, makes deals flow. And what Jerry said about the filing service, you know, it may not seem that significant, but it is, you know, when we're trying to get a deal done, when you're trying to sell your company, and you know you've got a big paycheck on the line, and you can't get your documents out of New Jersey, when Delaware would just, you know, shoot them right through, those things start to matter. Yeah, so they're significant.
I'm sensitive to time, so I'm going to move to the next slide, which is Delaware. Delaware. We've kind of talked about this a bit, so I'm just going to breeze through this. We've kind of hammered home that we love Delaware. New York, you know, we've talked this through too. You know, not widely as used as Delaware, and we've talked about publication. And then home state, you know, if you're, I think the example actually was just given from the audience, that if you're in New Jersey and you're operating in New Jersey, maybe it makes sense to just stay in New Jersey until you need to move over. So now we're in the governance.
The IP, you know, protecting an investor, early investors, or an owner's IP. How does it, I mean, which state you are, how does it affect California, New York, Delaware? You know, if I want to make sure, I mean, I made so much of, you know, new coding in my software, I don't want somebody to later on say that was his. From my point of view, if I'm the original coder, which of these states would be best for me?
Well, first off, bear in mind that where you form first starts with where you're located. Because the first issue is where are you, right? If you're here in New York, even if you thought that California somehow or other had some better benefit for you, it would make no sense for you to form a company in Delaware and in California and then qualify it in New York. The reason why we do that in Delaware is because of the financing issues, right? So I just want to put that out first, that the primary issue is not protecting IP. The second thing is, while some states are more protective of certain types of IP than other states, California, for example, highly protective of IP associated with the entertainment industry. You know, New York maybe less so. Fundamentally, it's not a matter of state law, really. I mean, aside from non-disclosure agreements, copyright law, patent law, and trademark law are all federal statutes or federal law. So in my view, it doesn't, the differences are not significant enough to really consider them when you're deciding where to form.
Yeah, I agree with that.
I would add.
Okay,
I'd
we'll
add
take 2 more questions and then we're
Helen,
moving on
could
to
I-
governance.
Could I add 1 or 2 points to
Okay,
that?
4.
First of all, distinguish between the law of the entity of, the law of the state of formation versus the law that may apply to contracts. So while we may form entities in Delaware, when that entity enters into contracts, it may be New York law that applies. Because the commercial law in New York is a body of law that we, as lawyers, we like, is very, so we often find we'll be applying New York law to the contract, even if the entity is formed in Delaware. And there are other reasons for that as well that I won't go into. The other thing, just a quick point on the IP, this is kind of like sort of a whole different issue, but I'll just throw it out there. Often you may want to think about whether the IP even belongs in the U.S. I mean, I often counsel clients to think about having the IP offshore, because if they're going to have international operations and they're going to have revenue, abroad, they may want the IP held in another jurisdiction entirely. But that goes beyond this conversation, but it's at least something to think about.
Okay, 1 and then.
A quick question I had is, you talk about forming in Delaware, but can you form in Delaware without doing business in Delaware?
Yes.
Okay, so they don't require that you.
They'll take your 200.
They'll take your money.
Yeah,
They'll take your
They'll take your
It's like
money.
all comers on that one. Yeah, everybody.
They'll all take your
You
money.
can write the check.
Okay, right here and then back there.
Ask really quick before we move on, publication. What happens if you don't do publication requirements?
All right.
Well,
there's a little, yeah.
And if you don't fulfill those requirements, are you able to do it post 120 days, or are you penalized for that? Or what are the implications for that? Does that?
I think you can do it. I have a lot of small clients that I'll tell them, if you didn't do the publication, really, they say they could judicially dissolve you after 180 days if you don't, but it really doesn't happen in New York. I don't think they pay much attention to it. And I've had plenty of clients who've cured after the 180-day period. So there's a little thing you can do. You can sort of wait to see if you get the money, and you don't want, wait till you raise a little bit of money, and so we'll see if the business goes before you actually pay for the publication. You're not really supposed to. You're supposed to really do that publication within 180 days, but I don't think there's really any, since you can cure it, there's really no, real effect of it if you don't do it.
But having said that, it is the law of the land.
Yes.
To be clear.
As
The law of New York.
Break the law.
Okay, as lawyers, we're not counseling you
Yes,
to ignore
exactly.
the requirements of New York law.
Okay, in the back.
Does a Nevada corporation have any relevance in any part of this discussion?
If we were in California, talking about forming companies, it might, because there are lawyers in California that use Nevada as a location to form their startups, but we don't. It serves no purpose to us here. No one here in the East Coast has any knowledge about what Nevada's corporate law is, nor do we care about the fact that they don't have a corporate income tax.
Although Nevada is gaining some
Yeah,
ground.
it's
Yeah.
trying to be the next Delaware.
Yeah.
It is.
So, but as a practical matter, we're still forming in Delaware. So.
Okay, so now we finally get to governance, ownership, and other considerations. So for corporations, how many classes of stock are you going to have? What are people contributing for their equity? What's the composition of the board? Who has control? Titles for officers, and what are their roles and duties and responsibilities going to be? So these are kind of, once you've actually settled in and decided I'm forming a corporation, this is the next level. This is kind of, okay, how is this thing actually going to work? What fits together? Similarly, for LLCs, it's the name, it's the initial capital contributions and membership interests. Here there's a little bit of a twist, right? Because again, the ownership and the control and the allocations don't all necessarily fit together the same way. So in a corporation, you may have a stockholder that owns 50% of the company and therefore, or 51%, and therefore has control. But in an LLC, you might have a different type of structure where just because you have 50% doesn't necessarily entitle you to full control, or doesn't necessarily entitle you to 50% of the distributions. I mean, LLCs are kind of a creature of whatever you create. Then we get to transfer considerations, exit issues. These are really the kind of more complex issues that you really should be working through with your lawyer when you set up your business. One of the biggest things, one of the first things I always try to set up with founders is vesting. So oftentimes when you're setting up a startup, you don't really have much money. Maybe you're putting a nominal amount of cash into the business. And really the value that each of the founders is bringing to the table is their skill, their actual service to the business. And they get that third of a share, third of the ownership interest in the business, because the expectation is that they're going to carry that business through by providing certain services over a period of time. So if you just grant someone, a third, 33% of the ownership of the business, and then the next day they decide, well, hey, I actually don't want to do this anymore, and you've got no mechanism to get that equity back, you're really in trouble. And oftentimes a lot of founders, come in having already gone on LegalZoom, let's say, and formed a business and issued equity without any real kind of strings attached. And so vesting is really the best way to kind of create those strings, to say you've got to earn that equity over time, and it vests over time. And if you should leave the company, before that equity fully vests, the company has a right to buy it back, typically at a very nominal price.
And let us underscore, vesting is not just for the VCs. It's for you as the founders. And as Helen says, when I have a group of founders that come in, we go through all the issues, things that they need to talk about, and at some point we get to vesting, and I say, is there going to be vesting in the agreement? And often the reaction is, well, why would we want to do that? And we give them the example that Helen, it's the three of you now. If tomorrow one of you decides I'm going to go off surfing, and leave the other two to run the company, and you just freeload, it's not a happy day. So that it's for your benefit as founders when you have partners that you get reverse vesting.
And believe me, it actually has happened.
Yes.
I think it's happened all.
It happens often, more often than you think.
And just to underscore something that Paul and Jerry both talked about early in the presentation is the idea that the documentation concerning what people own in the company, do it early. I can't tell you how many. I had one today. We were selling 50% of a company for a significant amount of money, and the guy said to me, yeah, well, we own 50%, but there's this other guy who really owns 5%, but we never gave it to him. And it not only does it create an issue in just terms of, okay, kind of figuring out how we do all that and explaining it to the buyer, but it also presents a huge tax issue, because now that equity might have been given to this person who was the COO of the company when the company had very little or nominal value. Fast forward 3 years later, now the company has an event where it's really truly being valued by a third party, and it's in several $1 million. So his 5% interest, which might have been worth $3,000 3 years ago, is now worth $250,000. And if he gets it today, he's going to have $250,000 worth of taxable income with no cash to pay the tax on it. So it does create some very serious problems when you don't memorialize these equity arrangements early when you have a startup.
And I'd say that for all of these issues, that on these structural issues, time is not your friend. They will never be easier to resolve than they are on day one, and they just get more complicated and more difficult. And they, tax factors, as Kevin says, or disagreements among founders, or misunderstandings, or whatever it is. If you don't do it in the beginning, it can get so messy so fast.
And I just as a footnote to that, on tiebreakers, oftentimes you have a situation where you might just have two owners and it's 50-50 at the very beginning. How do you deal with a decision that you don't agree on? If you can't agree, can the business move forward? And that's like a fundamental question that you don't want to wait until the business has developed real value and traction and people are adopting whatever it is that you're putting out there to figure out how you're going to handle that business problem, because it's a real problem. The next couple slides really also deal with kind of fundamentals at the beginning. The initial capitalization of the company, how much are each of you putting in for your equity? And are you putting it in as equity, or are you putting it in as a loan? And this is something that a lot of founders come to me and say, I've spent all this money, I've been traveling, to find developers, I've been putting in all this cash, I should have X% of the company, or I should get reimbursed. And there's this wishy-washiness about whether the money that they're spending on the business is their equity contribution or whether it's debt that they expect to be paid back. And understanding the fundamental difference between loaning the company money on the expectation that if the company is able, it will pay you back with interest, versus putting in cash into the company for your equity on the understanding that if the company doesn't do well, you might never get paid. And that understanding that difference, the debt equity difference, I think is a really important point for founders.
Can I just make one observation about that, which is that there are many things that investors do that they like to do and they don't like to do. One of the things that they absolutely hate to do is to put money into a company and see it go out to the founders. They will not do it. So you can think about it all you want. You need to be realistic about it, because when push comes to shove, if you're lucky to get to that point, they're going to force you to turn it into equity.
This last bullet on valuation, all dilution, use of proceeds concerns, all of those are going to be dealt with at the financing event, which is part of this 4-part series that NYTECH's providing. So all those juicy details, you can hear about them at the next presentation. And then the last slide, just to round everything off, is obviously securities law compliance. So if you're going to be issuing equity to investors, issuing equity to advisors, employees, you want to engage counsel, you want to engage your accountants, you want to have the right professionals backing you as you go through that process. Jerry and the panel have already given illustrations of, if you don't do it properly, there can be income to someone and, no cash to pay it. So a couple of things on here also related to licensed broker-dealers. So this is another, I'm just throwing it out there, that if someone says to you, I can help you raise money if you just pay me a fee, run away. Run very, very far away, because chances are they are not a licensed broker-dealer and you're potentially getting the company in pretty big trouble. And that's the licensed broker-dealer issue is one of the issues that we really, as startup counsel, face very often. Someone getting paid a success fee, but they're not licensed.
I mean, if they're licensed, that's one thing. But more often than not, at the startup stage, it's an unregistered finder. And it's, as Helen says, it's bad news.
So I guess I'll just go
Can I just throw in one thing on the securities laws? This is sort of always the last slide of this event, and we kind of go over it and move on. But I think it's worth underscoring that when you're giving equity to people, there are 3 ways to give equity. It's either a registered offering, it's exempt, or it's illegal. Those are the 3 ways to give equity out. And it's not generally going to be a registered offering for an early stage company.
You only have one.
And you don't want it to be illegal, so therefore it has to be subject to an exemption. And just thinking that, there must be some way that this is going to be okay is not an exemption. This is one area where you really need to speak to a lawyer who knows what they're doing and make sure that you're doing it right. It's not difficult. It's generally not difficult to issue equity. There are generally relatively easy exemptions that you can apply for, or that you can qualify for, but you need to make sure you know which one you qualify for, and that if there are requirements or filings, those filings are made, because if they are, although it can generally be done relatively easily in the beginning, cleaning it up after the fact can be difficult, can be expensive. Sometimes it's not really possible. There are civil and criminal penalties. And I guess the last thing I'd say is be aware that that's giving equity to anyone. Usually founders are relatively easy, but after, your friends, your family, your landlord, your housekeeper, anyone who you're giving equity, even if it's just a little bit, or, again, doesn't mean that it's going to be difficult, but make sure you're talking to a lawyer so you do it right.
The last thing I just want to highlight on here is the Jobs Act and the new regulations that are on the books now. I think there are a lot of folks that now think, the Jobs Act and crowdfunding, and I can just kind of go out and raise whatever I want to raise and give people equity, and that's not really what the Jobs Act does. This panel is not meant to discuss the specifics of the Jobs Act, but there are still the basic prohibitions still apply. So you want to make sure that you're involving counsel if you're going to rely on any of those new laws. So I'm going to leave it there. These are the takeaways, and we're just at 8. But if people have questions, we can open up the floor to questions.
So, question around publications. The lawyer told me that it's expensive to do it in New York City in the 5 boroughs, so he'll do it in Rockland, file there, publish there, save maybe $1,800, and maybe transfer the LLC to Brooklyn later on. Is that okay? Is that done?
Well, first off, where you publish and where you do business in the state are irrelevant. You publish once when you form in the jurisdiction in which you're claiming you're setting up. And then you can do business all throughout the state. You don't have to publish again.
So maybe it works.
Well, no, the issue there is, and I'll tell you, because we confront this issue all the time, and we're always looking for cheap ways of publishing and, for our clients. What we came across about 6 months ago was a position that was being taken by some of the service companies that you could publish in Albany. Didn't matter if you had an office there or not. And they were telling people to do that. And there are companies that people that handle publications who will do that for you. And we've had clients do that. And I don't know that it's actually okay. It's very unclear. The statute really is unclear about where that place has to be. Although, the implication is that it should be where you're actually setting up your place of business. In that county is where you should be publishing. But there are other schools of thought. And you can find cheaper ways of publishing if you look hard, even in New York. You can find publication for less. You just have to be persistent.
But it sounds reasonable. It does sound like a reasonable way to go about it.
Don't you have to indicate your business address that you're using at the time that you publish?
No, you put down the county on the certificate.
Just the county?
Yeah.
Yeah, well, I've had clients who have done that when they have actually had an address somewhere else.
Yeah.
They're going to be doing business in New York, but they have a summer house in the Catskills or something like that, and they'll use that Catskills address, and then they'll transfer it to New York. I have not had clients do it when they didn't have a legitimate address in that jurisdiction. I'm sure people are doing that. I just haven't been involved.
That's been our position too, up until the time that I heard this, and I'm still actually uncomfortable about the idea of just publishing in Albany. I prefer that they have an address someplace. But the other part of this is that, notwithstanding it's been in effect, this law has been in effect for 15 years or more, and I'm not aware of any violation of it ever being enforced.
There's a question back here.
So,
how difficult and how long and what would it cost to convert a New York LLC to a Delaware corporation?
to just do the conversion, very easy, and it's not expensive.
What is not expensive?
I don't know the numbers off the top, but I mean the filing fees are maybe $1,000.
Yeah.
And the forms are very simple.
I asked you to do it. How long would it take? What would you charge?
Well, I can't tell you what the filing fees are because I'd have to ask my paralegals what they are. But I know that it's not expensive.
I just did it with a company. I don't know the cost, but basically you have to set up an entity in Delaware, so there's several $100s of filing fees there. You have to merge your New York entity into the Delaware entity, so you have certificates of merger filed in Delaware and New York, and there's probably several $100s of filing fees associated with each one. But one thing you got to be a little bit mindful of is now whatever contractual arrangements, whether you have a lease or contracts that sit in that New York company, you got to be careful that you're actually transferring everything from one entity to another entity. So your New York entity really doesn't exist anymore. It's being merged out of existence. Well, I mean, all that stuff will naturally follow because it's a merger, and by operation of law, everything will go over. But you might have some contracts that would prohibit an assignment like that. Like typically a lease might say, if you do that, that constitutes an assignment. You might need landlord's approval before you can do a transaction. So it's from a legal standpoint, it's not that complicated. It's probably a couple of $1,000s worth of cost. But if you have contractual arrangements in the existing operating entity, you might want to look at that to make sure there's no issue there.
I think the other thing I'd say is that assumes that the capital structure is very simple.
Right.
If you've complicated your capital structure,
that's true.
that'll add to your cost.
I think we'll stick around for a little bit. I think
Yeah.
we're gonna wrap here. I want to just say thank you, and please be sure to attend